terms of asking parole officers to decide the agency, especially now that the parole officers are at CBSA, there is this trade-off between the parole lens and the agency lens, and if you don't have to, sometimes I do wonder if there's a benefit of having the agency decided at CIC rather than by CBSA, but oftentimes of the essence at that point. So, this should have said, and I make this error throughout, judicial review of A44-2 decisions. So I think this should be review at this point. If serious criminality or criminality is triggered, the officer under 44-1A may prepare this inadmissibility report alleging that the person is inadmissible to Canada because of criminality. It then proceeds to subsection A44-2, where a decision has to be made about whether to refer the person to the Immigration Division. Once you're at the Immigration Division, you're going to lose. And then the question is, what happens next? You automatically lose your permanent resident status when the removal order comes into force. That happens the moment that it's delivered if you have no right of appeal and it's not stayed. So I'll just leave that there and we can move on. So, contrary to what the Act says, according to the Court of Appeal, where it says under subsection 44.1 that an officer may prepare an inadmissibility report and forward it to the minister, the Court of Appeal says that Parliament actually intended to use the word shall there, and that may is actually must or shall, according to the Court of Appeal. They say this is a common statutory interpretation technique that I have not seen in any other statutory interpretation case, but in this case, may means must. So if you have criminality and it gets before an immigration officer, there will be this report. And then what happens next is where all the work comes. So the Supreme Court of Canada has said recently in the Trans decision that the minister or their delegate has discretion not to forward an otherwise well-founded report to the Immigration Division. So if I was to backtrack to when these legislative amendments were happening, CIC took the position that the full circumstances of a permanent resident, especially a long-term resident, were supposed to be determined at the front end of the removal process before any steps were taken to remove them. We go through this period of time where the Court of Appeal and CBSA tries to narrow that substantially. The Supreme Court in Tran, and this is obiter, but I think it's still valuable, does say there's this two-step process. Is the report well-founded? In Tran, it was not. That's why this comment is obiter. The second is, should this person be referred to the Immigration Division, knowing that if the report is well-founded and the person's referred to the Immigration Division, there will be a deportation order at the next stage. That happens because, and this is the third bullet, at the Immigration Division, has extremely limited discretion at an admissibility hearing, and they must make that applicable removal order if the report is well-founded. So all our work at this point to prevent somebody from losing their status is going to happen at this referral stage. Some common mistakes that I've seen are that people wait to bring a judicial review application until after the deportation order has been issued. That is a mistake. It's 15 days from the time the referral decision has been made. In these cases, the duty of fairness is not at the high end of the spectrum. reasonableness is also up for debate, but the most useful or pro-permanent resident case says the minister must provide brief reasons for rejection of submissions. This is Melendez. And then more recently, in the Abdi decision, the court says that referral discretion must be exercised in accordance with charter protections and international human rights law. That's both a statutory obligation and a common law obligation. So, pardon me? Yeah, it was helpful. And then for the immigration lawyers in the room, I would just say this is a plug, I think, for proposing a certified question that you think is a genuine certified question that is of general importance to the legal community, and you think may be dispositive of the case, because we did that in Abdi because we thought the matter was unsettled, and the court came back and said, no, we're not certifying this question because it's well-settled law that this is the answer. Well, that's very useful then in future cases to be able to say, this is so well settled according to the federal court that we shouldn't be arguing about this. So I think that then makes the precedent a bit more helpful. So for criminal counsel, I think the first action is to engage immigration counsel as soon as a foreign national or permanent resident is facing a reasonable prospect of conviction for a criminal code offense or other act of parliament that's going to trigger section 36. And the reason for this is that this deportation apparatus is going to spring into action before the criminal courts have even finished with the matter. So oftentimes, we could be at the point of deportation and removal, and there's still an appeal pending with good grounds for the criminal charge that underscores the deportation. The second thing I would say is that in terms of what you can contribute other than flagging it to immigration counsel, on these referral cases, to overly simplify the balancing, it's a competition between public safety, how dangerous is this person to Canadian society, and their rehabilitation or other factors. We could call those humanitarian and compassionate factors, other attachment factors to Canada. And I think what's really helpful from criminal counsel is getting things like the judge's reasons for sentencing or other circumstances about the offense that suggests it's at the lower end of the spectrum. For those of us that do not do much criminal law, I wouldn't be able to tell you off the top of my head, well, 2 years for this violation is low, medium, or high. I could do that work, but it would be rather useful if, if this is a criminal law nothing burger to you, then it would be helpful to know that and to know why, to be able to convey that to the immigration officer. And this comes up especially in things like manslaughter, where there's this massive range of moral responsibility for the offense. The offense is serious in and of itself, but the conduct that underscores that offense might be quite variable. So help for that is useful. And then I guess the last message is that you really do need robust submissions at the referral stage, pursuant to the guidelines, any charter protections that you think apply, and international human rights law, if it's relevant. So this next part assumes that you've lost, and now you're really at the end of the road, and you've got an enforceable removal order. Parliament is pretty clear here that a removal order is enforceable if it has come into force. What that means is that you have to leave. There's no more stops in the process. They're very clear that that enforceable removal order is enforceable, which means you have to leave Canada. There are a number of situations where there's a statutory stay that will stop that removal order. They're up on the slide, but you can have a ministerial stay because of something going on in the country. You can have a stay because there's a judicial review application going on, but not if the person's inadmissible because of serious criminality. You can have a stay, as we've learned, from an ongoing PRA, though not necessarily the second PRA. You can have a ministerial stay for H&C reasons. And then this next one, which I think is most relevant to Criminal Law Council Regulation 234, is that there is a statutory stay during a term of imprisonment, or if you've been subpoenaed to attend a court case. That can be waived if charges are withdrawn or the summons is withdrawn. So the Crown can enter into an agreement that will remove that statutory stay. The discretion, if there's limited discretion at the referral stage, there's even less discretion at the deferral of removal stage. The Court of Appeal is very clear on this, that discretion is quote unquote very limited. The question is when the person can be reasonably, practically removed, not if removal will occur. So when you're requesting deferral, it can't be, no, this person really wants to stay forever. It needs to be, this is why a short-term extension of the when should be granted, not the if deferral, not if the person should be removed, but when they should be removed. So some of the factors that are relevant are the person's health. Again, this is not going to be a forever health concern, but it might be I need time to complete a course of treatment in Canada. I need time to set up the equivalent treatment in the other country, and this is what's going to happen if that's not set up. Other impediments to travel. The best interest of an affected child, but here the courts have been very clear that it's only their short-term interests, so this is not a full-blown H&C best interests. It's questions like, can we defer removal to let them finish their school year, or for some other short-term reason? Possibly a pending immigration application, but this, I think, really depends on how long pending means. So if an H&C is being filed a month ago, it's going to be a really slim basis for removal, because we know H&C applications are going to take 2 to 3 years to process. The courts say the person can be removed and the application can be processed while they're removed, whereas if it was submitted 2 to 3 years ago and you're right on the threshold of a decision, maybe that's going to be a stronger factor. Again, 15 days to JR a deferral of removal refusal. So the take home here again is engage early. Contributions that can be made if there's a summons or subpoena basis for somebody to be a witness, then that can be helpful. It also is helpful to be able to describe to Immigration Counsel what the timeline of an ongoing criminal or corrections process is, so that that can be brought into the short-term argument. And then I think there's this aspect, and this is not really a criminal law issue as it is just a decent human being issue, is that you start to identify personal or family-related issues that are going on in a file at an early time. And so that might be that there's a mental illness element or some other health element. In order to properly document those for a deferral request, it takes time. So to get letters from doctors, particularly psychiatrists or psychologists, to establish the basis for the request is something that can be started early. Again, robust submissions as to why deferral is warranted. So then, deferral is not being granted and you're facing a removal order with a date. You can bring a motion to stop removal. This is a typo. It's rarely a party when you're at the stay stage. In my experience, it's never been a party, or not one that I actually wanted to attend. And it's the regular RGR McDonald test for an injunction. In immigration law, the cool kids all call it the Toth test because that's an immigration case from the Court of Appeal, but it's the same test as the RGR McDonald test. It is conjunctive. You have to meet every single one of the steps. The first step is obviously a serious issue, then irreparable harm if no order was granted and the person is removed, and then balance of convenience. In terms of applying the test, a plug for the comments of Justice Sin, who I clerked for, not because I clerked for him, but because I think when the court tells us to do things, that's a big, strong hint that we should do them. When they tell us that certain things annoy them, we don't want to do those certain things, if we can. Or at least if we're going to do that, then we better show up extra nice. So, or something. So read that speech, it's helpful. Some of the takeaways is that there must be a decision under review with a prospect of success. So you can't just bring a stay application and say, I don't really want to be removed from Canada, ever. That's not going to carry the day. You need to be able to say, I've got a pending H&C application, or I've got a pending TRP application, or I've got something going on that may give me the right to remain in Canada. If that decision that you're relying on is a deferral request, that is to say, if all you've got is that short-term deferral request, then the court is clear that the serious issue prong is elevated. So normally, serious issue is much lower threshold, but if you're using an injunctive relief to get what you actually want, then winning the injunction wins the application, if that makes any sense. So if you have a pending H&C and you win the injunction, we wait and see what happens with the H&C. If it's just a deferral request and you win the injunction, well then they've decided the deferral request. With respect to appearance at trials and civil trials, criminal trials, civil trials, it's a bit split on this. For civil trials, the courts have said, no, that's not going to be a basis for a deferral. You can testify by video conference, you can give your evidence by affidavit, you can apply for a TRP to come back to Canada for the duration of the trial. In that one case I mentioned, they do note that a criminal trial might be different and that there's an upcoming criminal trial. And then I think the last thing that the court says, and this is one that I think I can fairly say has been passed on and rubbed into me, is that the stay must be timely. If you know the removal date, do not wait until just before that removal date to bring a stay. So you can always get a federal court judge 365 days a year at any time in their pajamas to do an emergency injunction, and this happens. But if you're going to get them up in their pajamas, there better be a really good reason why that is happening. Otherwise, they get a bit crotchety. So the message seems to be, if you can bring your motion for injunctive relief on a regular motion day, which we can't do in Halifax, but people can do in Montreal and Toronto, I think, and maybe Vancouver, then bring it on the regular motion day. If you can't do that, then bring it in advance, and if there's some impediment to that, then flag it to the court. Say, I've got this removal date, I'm going to be bringing a stay, I don't have a precise time. That gives the court an opportunity to plan for a judge to be in place. Again, injunctive relief is equitable. They don't have to give it to you. If they're really angry, they can just say no, and it is, you know, if you're only going to give somebody 24 hours to read a lot of materials, they're going to be really irritated with you. So the take home here again, engage early. Is there anything going on in the criminal process that might be irreparably harmed if this person is deported? And the final is that these motions for stay are technical and context specific, so they're probably best brought by Immigration Counsel. And happy to answer any questions. Yeah.
I'm waiting to the end, at least. So the serious issue to be tried, does it necessarily have to be underlying litigation, or can it be an agency? Or
It could be so.
If it's a motion, does it not?
So then it would be a deferral.
Like, do you always have to? So it's been, we haven't done it very many times, but it's kind of been our understanding that you put in the deferral request knowing it's going to be no, so you can JR that, so you can have that underlying litigation to bring forward the motion, but it's actually more about the fact that the agency is in the system.
Yeah, no, I think that then just gets you into the elevated serious issue test, but again, because it's equitable relief and a 3-prong test, and we don't spend much time on that third prong of balance and of convenience, I think that third prong is a place where a well-established agency that you filed in a timely manner and not just at the last second actually could be something that would be relevant.
And would you ever just ask for, so you're talking about the fact that it needs to be reasonably practical to remove, you know, the CBSA, it's a removal order that needs to be enforced. In practice, what kind of timelines would be best to ask for? Like, would you want to ask to defer removal until you can bring forward, you know, to file an agency, for instance? And would CBSA ever be
I don't think you're going to get that. I think if you're saying, can you defer so I can file an agency, the answer is going to be no. I think it's probably like quite context specific to person, place, and country. So if it's a kid and it's November, then I think it's not unreasonable to ask to finish the school year. If it's a healthy adult and a safe country, then I think your short-term window goes way down. Yeah.
The recent changes in the impaired driving law that makes it first offense breathalyzer. Technically 10 years if you go by indictment. Is there anything, is that arguable at some level, or is there case law? And also just the background made more criminal in nature is that for even hybrid offenses, if the Crown is elected to go and on the other charge that's hybrid summarily means the Crown has decided it's minor. But yet the law says it's going to be treated as indictable.
Right.
Is there any case law that has ruled on that, or is there stuff pending? Or
so there's 2 court cases pending that I didn't mention. One's called Ravel, the other is called Moretto. They were both unsuccessful at the trial level and have been heard by the Court of Appeal, where they're likely going to be unsuccessful, and then we'll see where it goes. But they deal with the constitutionality of this regime, and they've actually, so they've made an argument that on 12, which is cruel and unusual treatment, 7, and I think 2, Section 2 association for one of those cases, and the trial courts rejected all 3 grounds, and both courts differed on whether they thought Section 12 was engaged. This, of course, has happened before that recent Supreme Court of Canada case. I don't know the name for you. It's again not criminal law, but where they say, you know, $100 fine to a poor person can be cruel and unusual treatment. It's like, well, okay, if that's cruel and unusual, then I think removing somebody that came at age 5 and has lived here for 40 years because of a summary offense might also, well, you know, apples to apples. But again, the Court of Appeal, the Federal Court of Appeal, has taken this page or this repeated argument, and in 117D cases, which we were talking about earlier, that this agency is a constitutional savior. So, like, the Immigration and Refugee Protection Act could be a constitutional mess and maybe unconstitutional, but we have this agency provision, so it's this valve release that you can always apply for an agency. And so that has been used to save unconstitutional portions of the act, but I don't know. So there is 2 cases pending, and
Nova Scotia or somewhere else?
one's in BC, and I don't know if the other one's in Ontario or in BC as well, but somebody can chime in if they know. They're not the most sympathetic facts. They're not the worst facts either, so maybe that is, and we'll have to wait. The Court of Appeal has reserved on both of them. But I think, so if that goes the way of the referral process is constitutional, you could see either yes, cruel and unusual is triggered, but not by these facts, or no, it's not engaged at all, in which case we need to do something else. This is why I've been reluctantly getting back to charter values, which are not my favorite cup of tea, but I think actually gives space to make some of these arguments potentially at the referral stage, especially if you get a chance to make submissions, because they may, it's unclear what charter values actually are still, so there's scope to develop that. And 2, then if you can get a charter value, then it might get you, what triggering a charter value gets you is a proportionate balancing based on statutory objectives. And the statutory objectives are public safety and family reunification are the 2 ones that twin out in this case. And this comes back to your, on public safety, if this person is not a risk, then in that balancing, the family reunification needs to win out. And so I think that's why justice has pushed hard against charter values, is because they don't want officers to have to balance the statutory objectives and actually look at public safety. But I'll stop talking now and take your question. Yeah.
Oh, sorry.
Oh, I thought you looked like I'm going to take your question. Yeah.
Some of the most interesting arguments you've seen for stays, maybe working.
I did keep a list of bad.
Yeah, I had a question too, somewhere around the irreparable harm. What
So,
can be put in that?
yeah, so I think read Justice Zinn's speech. I think what he wants is an unspun. So he says, actually put all your works on the table if you have them, because and I think client there showing some degree of contrition, especially if it's a young person, goes a long way when it comes to stays. Yeah.
Yeah, that was around
Yeah.
the second part of the 3-party test.
Yeah.
The irreparable, the irreparable harm.
Yeah.
Obviously, risk-based. So if you have a situation where a PROC has been decided negatively, because it happens, and then you're bringing forward a JR of that, then you can say, no, we think this was decided in error, he is subject to persecution, and that's the harm there that you use for the stay.
That's
I mean,
right.
you invoke that. But are there-
Suresh does this too. The Suresh case where they say, a person should be able to benefit from the pending court case
Yeah.
because if they're right and they actually are at risk, then it would be a grave injustice too.
Yeah, so that's a pretty
But
easy
then-
one that
yeah.
risk is harm, but what other things are harm?
Oh, and so it needs to be focused on the person that's actually being removed. It can't be all, like, you can bring in extraneous stuff, but there better be something for that person. And I think because the test is conjunctive, there's always where's your strongest point and try to lead out from there. Yeah.
And what about best interest of the child in that stay? Where, does that fit
Are
into
they being
the-
removed or not removed?
No, they're being not removed.
So then,
No.
I think you can bring it in, but the stay is not an opportunity to rehash the underlying application. So it's not that it's. I don't think that children's interests should ever be not included. I think they should always be included. But there needs to be something else there.
I guess that would be the serious issue if you've got an agency with the best interest of the
Yeah.
child.
Yeah.
Where there's a conviction or a sentence that triggers these proceedings, does it make a difference if there is an appeal prior to the report or after the report? Does the timeline change?
Yeah, so no, appeal makes no difference. I've got a case right now where I think I'm not doing the appeal, but I think the appeal's quite reasonably strong, and doesn't do anything. So the deportation apparatus will be continuing, and of course, we've flagged. It's always a bit of a tight balance, right? Because if you want to say that there's this balance between public safety, rehabilitation, and connection to Canada, then you need to own some of the criminal conduct. And if there's a pending appeal, it's a bit of a dance between, you really need the person to be able to say, I did this, I acknowledge it was wrong, this is why I'm fully rehabilitated. It doesn't carry the day to say, I didn't do that, because from an immigration law perspective, then there's no rehabilitation or insight or basis for a second chance. So that's a struggle, but
What about a sentence?
same. A sentence appeal is not going to matter that much unless it's the difference between access to the Immigration Appeal Division. It's going to trigger 36 no matter what, and then the only question is whether or not you're above that 6-month window that then denies you access to the Appeal Division.
Yeah. We had someone who was removed, and we brought forward so this person had a sentence of 2 years. It was before the faster removal, before the Criminals Act, and with legal aid, we did a sentence appeal, reopening of the sentence appeal to get it to 2 years less a day.
Yeah.
And they still proceeded with removal. We did a deferral request, and then we brought forward a stay, and it was denied. And that was after the appeal, even after the 2 years
Yeah.
less a day. So it was still.
The only benefit I would say is that correction. So if you've got somebody that's gone through the correctional process, I would say that and the parole process,